The phone rings within hours of your accident. The voice on the other end is calm, professional, almost warm. They say they're from the insurance company. They want to help you get your claim taken care of, and they just need to get a few minutes of your time to get your statement. Most people do it. They talk. They answer every question, and then they wonder months later why their claim came back so low, why the injuries they carefully documented got dismissed, why the insurance company seemed to know exactly what to say to minimize what they owed. Here's what that insurance adjuster did not tell you when they called, and it may be the most important thing you hear after a California car accident. Let me start with something most people never think about. An insurance adjuster is not your friend. They are not neutral. They work for the insurance company, and the insurance company's goal is to pay you as little as possible on your claim. That's not, a cynical view. That is literally how these companies operate. They have shareholders, they have profit margins, and an adjuster who keeps payouts low is an adjuster who keeps their job. So what does that mean? It doesn't mean adjusters are dishonest people. Most of them are just doing their job and what they're trained to do, but understanding their role changes everything about how you interact with them. The first call is not what it seems. When an adjuster calls you within hours of an accident, they have a specific goal. They want to get your statement while the events are fresh, but also while you're still shaken, still stressed, still unclear about the full extent of your injuries. Adrenaline masks pain. Shock does too. A soft tissue injury that does not show up until day 3, a concussion symptom that emerges a week later, none of that is in your statement if you give it on the day of the crash. And once you've given that statement, it is locked in. Whatever you said about how you feel, how fast cars were going, where you were looking, that is now the official record. If your account changes later, even because you remembered something new or your injuries developed, the adjuster will use the inconsistency against you. Here's something most people in California do not know. You have no legal obligation to give a recorded statement to the other driver's insurance company, none whatsoever. California is a two-party consent state when it comes to recordings. Under California Penal Code Section 632, it is actually illegal to record a conversation without the consent of all parties. An adjuster is required to inform you that the call will be recorded and obtain your permission. You can decline politely. You can simply say, I prefer not to give a recorded statement at this time, and I will be in touch. That is not obstructing the investigation. That is exercising your legal right. Now, if you are dealing with your own insurance company, the situation is a little different. Most auto policies include what is called a duty to cooperate clause. If you filed a claim under your own policy, say for collision coverage or uninsured motorist benefits, your insurer may have a contractual right to your cooperation, which can include answering their questions. But even then, you are rarely required to give a recorded statement in their format, on their schedule, without counsel present. You can ask to respond in writing. You can ask to have your attorney communicate on your behalf. So what adjusters are actually listening for when an adjuster takes a recorded statement, they are building a file, and they are listening for very specific things. First, they want to hear you minimize your injuries. If you say anything like, I feel okay, it's not that bad, I might have a little soreness, that statement will be in the file when you submit medical bills for treatment that started 2 weeks later. The adjuster will argue the injuries were minor at the time of the accident and must have come from something else. Second, they want inconsistencies. Were you going 25 or 30 miles an hour? Did you see the other car before or after it entered the intersection? Small variations in how you tell the story, even variations that mean nothing to you, become ammunition for denying or reducing your claim. Third, they want comparative fault. California follows a pure comparative fault system, which means your damages can be reduced by whatever percentage of fault is assigned to you. Under California Civil Code Section 1714, even if you are 90% at fault, you can still recover the 10% from the other party. But adjusters know that if they can get you to say anything that suggests you were even slightly inattentive, checking your mirror, slowing for a light, adjusting the radio, they can use it to shift more fault to you and reduce what they have to pay. So let's talk about the tactics they use. In my 30 years representing injury victims in California, I've seen adjusters use a handful of consistent tactics that you should know about before you ever pick up the phone. One is false urgency. They call quickly. They use phrases like, "We just need to close this out. We want to get your claim moving." And they imply that the longer you wait to give a statement, the longer you will wait for money. That's a pressure tactic. You are not losing anything by waiting. Another is sympathy. Some adjusters are genuinely warm and easy to talk to. That is intentional. The more comfortable you feel, the more you talk. The more you talk, the more they have on record. A third is the medical question. They will ask how you are feeling, sometimes multiple times in different ways. Any pain today? How are you sleeping? Are you back to your normal activities? These are not wellness check-ins. These are information gathering questions designed for your file. So let's talk about what you do when they call. Get their name, get the claim number, get the insurance company name, write it down or take a screenshot of the call on your phone. Tell them you're still receiving medical treatment and you are not in a position to give a recorded statement at this time. If they push, you can simply say, "I plan to consult with an attorney before discussing the details of the accident." That is a perfectly reasonable thing to say, and a legitimate adjuster will respect it. Then, do consult with an attorney. Most personal injury attorneys, including our firm, offer free consultations. You are not committing to anything. You are just making sure you understand your rights before you say something that can be used against you later. Once you have retained counsel, your attorney communicates directly with the insurance company. So at that point, you don't have to take their calls anymore, and that alone removes an enormous amount of pressure and protects you from the common mistakes that reduce settlement values. So let's talk about the bigger picture. Insurance companies in California are governed by the Fair Claims Settlement Practices regulations found in Title 10 of the California Code of Regulations, Section 2695.1 through 2695.14. These regulations require adjusters to investigate claims fairly, respond to communications within 15 days, and accept or deny claims within 40 days of receiving proof of the claim. They have rules they must follow, but those rules do not mean they are working for you. There is a difference between following the law and advocating for your best outcome. Only you and the attorney you choose to work with are in the business of maximizing your recovery. I've been doing this exclusively for plaintiffs for over 30 years. Every case I've ever handled has been on the injured person's side. And in that time, the single most common mistake I see people giving statements they did not want to or have to give. Before they understood the consequences, before they knew the full extent of their injuries, and before they had anyone in their corner. You don't have to make that mistake. If you drive in Los Angeles, there's a second video you need to see because where you drive matters as much as what you do after the crash. I put together a breakdown of the most dangerous freeways in Los Angeles, ranked by actual accident per data mile. Some of the numbers will genuinely surprise you. The link is on the screen right now, so I'll see you on that one.